Hello and welcome to Legally Speaking with me, Tarun Nangia. Today we are going to deal with a very interesting question of law. Is a statutory authority a secured creditor under the Insolvency and Bankruptcy Code? In a few recent cases, this has been dealt with, namely also the JP case and a few other cases. This is what we are going to discuss today. Understand what is a statutory creditor, about whether he's a secured creditor under IBC and so on and so forth. I have somebody who understands this subject very well today with me. Advocate Ishna Kumar joins me on the show today. Good to see you, Ishna, and thank you for your time.
Hi, thank you.
So at the outset, let me, in a sense, for the interest of my viewers, want to know from you, what is a statutory authority under the Insolvency Bankruptcy Code when the company is going in an insolvency process? Who comes under the category of a statutory authority?
Yeah, right. So Tarun, basically under the Insolvency and Bankruptcy Code, operational creditors is something that is defined, and that is what includes the central and the state authorities, and these are what we call the statutory authorities. And why do we call them statutory authorities is basically because they are governed by a statute. Like, you've seen National Highway Authority of India, or for that matter even Noida, which is the Noida Authority, and so on and so forth. There is a Yamuna Expressway, which was a matter which recently which mentioned about JP. So all these, which are really governed by a statutory authority, by a statute itself, become a statutory authority. So that's how the code also recognizes.
So basically, for the interest of my viewer, a municipal corporation is a statutory authority.
Yes.
Like Noida Authority, the Ghaziabad Development, or the DDA, which is the Delhi Development Authority, all these authorities are statutory authorities.
Even VAT, for that matter, like the Gujarat VAT, that would also be a statutory authority, or all GST departments. All of them are statutory.
So any government body,
yes,
for which a company has to pay dues,
yes,
while it is undergoing an insolvency process, is a statutory authority.
If it is governed by a statute.
If it's governed by a statute. Okay.
Yes.
Moving ahead, our principal question, whether a statutory authority is a secured creditor under IBC, if you could answer this in detail.
Basically, secured creditor, this issue really came up, recently in a judgment of state tax versus Rainbow. Which was authored by this is basically State Tax Officer versus Rainbow Papers Limited.
Okay.
And this is a 2023 judgment which was authored by Justice Indira Banerjee while she was at the Supreme Court there. So this judgment, basically, that's how the issue really came up, because it undisputedly operational statutory authorities were operational creditors. There was no dispute about it. Even on date there isn't. But the question really arose as to whether they are a secured creditor or not. And what do I mean when I say secured creditor? Is that whether they have a security interest in the asset of the corporate debtor, the corporate debtor being the company which is undergoing insolvency. Now, and why next comes is, why is this question important? And while especially dealing with a corporate insolvency resolution process, why would the category of a statutory creditor being that of a secured creditor make any difference? That is, I think, one question that everybody would want to know. And I think the reason for that is that the Insolvency and Bankruptcy Code mandatorily provides that for a operational creditor, irrespective it's secured or not, you have to give the minimum liquidation value.
Minimum liquidation value. It has to be given to a secured creditor.
It has to be given to any operational creditor.
Okay.
So now the question is, for a statutory authority, what would be that liquidation value? And how do we calculate this liquidation value? So this liquidation value is calculated according to the priority in terms that which class does it belong to. If it belongs to, say, class 2, then it becomes a secured creditor and gets a preference, and therefore its liquidation value goes higher. So I'll just explain this a little more. So under section 53 of the Insolvency and Bankruptcy Code is basically what we call the waterfall is what is given. So the first head is the CIRP cost, that is the costs that are spent during the resolution.
Okay.
Under the second class are the secured creditors, and the workman dues which are pending since the past 2 months after the initiation of the resolution process. That is class 2. Then comes the third class, which are other workmen. Then the dues of the other workmen. Then the fourth class is the unsecured financial creditors. And then is the fifth class, which is in fact specifically the crown debts, and parallel to them are, if suppose your security is enforced, after that there is some amount of the creditor outstanding, that amount. So that is class 5. After that there are 3-4 more classes, but I think that's not really relevant for the discussion that we're having. But these 5, considering these 5 classes, now statutory authorities, if it's merely an operational creditor, comes in class 5, because it specifically states central and state authorities. Now as soon as they become secured creditors, they go to class 2.
So they get more money?
Yes, they get more money. Reason being that suppose 1,000 is the value
liquidation value, 1,000 crores.
Is the liquidation value of the is something that the resolution applicant is putting in the company. Let us take a case. Now how will that value be distributed? First will be to the first class, then to the second class, if remaining to the third. So that's how the money goes in the waterfall. That's why it's called the waterfall.
Yes. So
so therefore that's the priority. So here what happens is, if you are if the statutory authority was a mere operational creditor, it went into class 5, and usually the liquidation value for such creditors was only was nil.
So basically you are saying until now, until the Rainbow Papers judgment, the statutory authorities, which are the government bodies, would get next to no money.
No money. Correct. So much so, even in the matter that we were handling in JP, the plan of Suraksha had in fact given, we've written it as 0.10 crore, that is 10 lakh rupees.
10 lakh.
Though the liquidation value in that case also was nil. Yes, we had just given it for the a notional amount. But what I'm saying is that the value for that matter was also nil. And here today we are at a stage where Yamuna Expressway, which was a statutory authority, has been recognized by the NCL80 because of the judgment of Rainbow, and after that, which I earlier mentioned, and after that the judgment of Greater Noida Industrial Development versus Prabjeet.
This is another judgment.
Yeah, this is another judgment of 2024, where Greater Noida was recognized as a statutory secured creditor.
So, I may want to interrupt here. So henceforth, after Rainbow Papers judgment, this is Prabjot versus
Greater Noida versus Prabjeet.
Prabjeet, that judgment, and now JP, which you were a part of.
Yes.
All government bodies will get much more money when a company is liquidated, because you're saying that they are now, from now on, under the category of secured creditors.
Secured creditors. But now, what? Just answering further to your question there, that what is the test? What does one have to look at to give the status of a secured creditor?
Now let me hold you here.
Yes.
Test as in, you are saying not all government bodies will be secured creditors.
Yes.
So a test, there should be. Then what is that test?
So that test is, you look at the act that they are being governed. Suppose the Greater Noida Authority is governed by the UP Industrial Act.
Okay.
Under that, section 13 and 13A of the Act puts a charge on all dues that run with the land. That dues running with the land meaning additional farmers' compensation, because the land has to come to me, or some compensation being given to the owner who was the earlier owner. So now, all the dues that are running with the land, those dues are being stated to have a charge, that meaning thereby if that is not paid by the company, then they have a charge on that land.
Okay.
So therefore, all dues that run with land were recognized under section 13 and 13A of the UP Industry Act to be a security that was in favor of this government authority, and therefore they are secured creditors.
Point well taken.
So therefore, as a result, so now coming to the test is, one, the act, that is the statutory authority that governs it, should provide for that security. Second, that security interest should be in a manner that it is notwithstanding the security interest of all other creditors. So it is possible that that very land will have a security interest of the other financial creditors.
Yes, also, of course.
So that interest has to be notwithstanding. If the section provides for it, then that statutory authority automatically becomes a secured creditor for the purpose of insolvency and bankruptcy court, irrespective of the fact that IBC is a specific law overriding all laws, irrespective of that
So
fact.
basically, until now, since the IBC came into force, the government bodies, for example, you said the NIDA Authority, the Yamuna Expressway Industrial Development Authority, or something like the Delhi Development Authority, or any authority, they were not getting money.
Correct.
From now on, they will get.
Correct. Correct.
And now this will be a bit too much to ask, but if you could just delve in and explain, why have the courts recognizing what fallacy in the law, or what was the need of the hour to veer this side? In your explanation, to push up their claim, basically from a category 4 or 5 you said to category 2. Why did this happen? If you could try and explain this to me.
Yeah, so I think the reason for that, I think, Tarun, is because the court does not recognize under 53 a distinction between financial creditor and operational creditor. It only says secured creditor and financial creditors.
Okay.
So therefore, the court, and also because of the reason that the section 53 waterfall in class 5 specifically provides state and central authorities. However, at the same time, the court felt that that does not mean that an operational creditor cannot be a secured creditor. They are well within their right to be recognized as a secured creditor, and therefore the law provided for a section, and they fitted it in that. And I believe.
Let me ask you a lame question from the point of view of the promoter. A vendor of the company which say provides taxi services, catering services, furniture, construction, etc. They are also an operational creditor.
Absolutely.
But they are not secured.
Yes.
Whereas the government bodies are secured.
Yes.
So the court in its wisdom has held that the rights of the government bodies, which is something like Noida, will have primacy over other vendors, which are vendors supplying or in service of the company. Could be taxi drivers or transport operators, could be vendors making furniture, could be maintenance, for example, air conditioning and refrigeration, which is common for all large. Their claims will be after the claims of the statutory authority are paid off.
Absolutely.
Now, one question that we come to because of all this, everybody wants to know, because there are headlines in the newspapers all the time that the liquidation value is a fraction of the cost of the whole plant or the whole project. So the liquidation value for all you know for a 10,000 crore project will be 1500 crores, which will be barely 15%. Maybe in some cases even lesser it could be, How is it calculated? Because a lot of people would want to know that why there is huge difference, huge difference. And why is this important? Because if in a 10,000 crore project liquidation value is only 1500 crores, then everybody will get next to nothing.
Correct. So the liquidation value, Tarun, under the code is calculated by valuers, first of all. After the
Official appointed by the NCLT?
Appointed by the COC, Committee of Creditors.
Committee of Creditors.
The Committee of Creditors being the financial creditors.
Which is the banks,
yes,
or the NBFCs,
yes,
who have financed.
And you must note here, statutory authorities are not a part of them.
They're separate.
Yes, because they are operational creditors. They sit outside the COC. In 90% cases, rare would be where there are no financial creditors.
Yes.
So, considering that the valuation is done by valuers who are expert in their field, and their valuation is done on the basis of the value of the asset that would be considering that the company has been declared insolvent or for, of course, the loss making. So there are two values that are calculated. One is the fair value and one is the liquidation value. And also the valuation is different depending upon the assets of the company, that sometimes, for plant and machinery, there could be different, two different valuers, and there are two different valuers.
So there will be very different grades of values, not just one, there could be 10, 12 values.
Absolutely. Like, in one of the matters I'm presently doing, there are 4 valuers for the same company.
4 valuers for the same company?
For 4 types of values, because there is land, for that we need different valuer, for the plant and machinery, and that is very interestingly an advertising company. So for the advertising, to calculate what would be the intellectual property value, we have a different valuer. So after that value is done, then it comes to the COC, and if the COC is not convinced, then in rare cases there is a third value that is appointed.
All banks need to agree?
Yes, all banks need to agree that yes, the valuation that has been done.
So they jointly appoint?
They jointly, the COC completely jointly appoints 2 valuers, and after that, if need be, a third valuer is appointed. So that is how a liquidation value is calculated by a valuer. But now, how is this liquidation value calculated under the code? If we look at it legally, that liquidation value is calculated according to 53, what I said, because the value of the asset of the company is what is calculated, it is not of the creditor. So now, how do you calculate the liquidation value of a creditor? Like in this case, like if you have to give the liquidation value to the operational creditors, that is according to 53. So therefore, that value which is being, why I said the value which is being infused, because for the purpose of corporate insolvency resolution process, the section 53 is notionally calculated. It is not actually done because it's not a liquidation that is happening. And then they basically proportionately put that value according to the priority.
Okay.
And that is how that's how the liquidation value of a secured creditor goes higher than a financial creditor also.
Just a question that comes to my mind.
Yes.
Can a secured creditor also be an unsecured creditor, or this is a firm classification?
No, so very, very interesting, and that's exactly what happened in the judgment of JP as well.
Which you were a part of?
Yes. So
You were for Suraksha.
I was for Suraksha.
Okay.
So Yamuna Expressway has been declared to be a secured creditor only for the purpose of the dues which were running for the land. But
Which is a pass-through because they have to pay land dues to farmers.
absolutely. But for the other dues, that is the external development charges, that is, or the internal development charges, for that they were held to be unsecured.
Is this a court's discretion in every case?
Yes.
Or is it, no, so it's specific to this case?
No,
Or
no.
it will be now
Oh no, I think it will apply. It will apply
all other cases involving land.
Yes, absolutely.
So
Because
it's not an exception to the rule.
no, it's not an exception to the rule.
So can you explain this again for the viewer?
Yes, why not? So basically, if the section of the Act says that the security is only for the purpose of land, which was the case for the Yamuna Expressway, which is also the case for Greater Noida, which is also the case
Land acquired from farmers which ended up with the company that's going under insolvency.
yes, or for that matter, any other tax or fee which runs with the land,
Right.
that will be secured creditor. But if there are other charges, suppose that government authority has any development charges that have to be taken from the company, for that purpose it is not.
It's a very interesting classification.
Yes.
So where a third party is involved, because in this case farmers are third party who have to receive compensation.
Yes.
That for that purpose they are secured creditor.
Yes.
But for their own charges which they levy,
Yes.
they are not.
Yes. So therefore, there they become at par with being a merely operational creditor. That's how. So it's a very interesting categorization because the same authority becomes a secured as well as an unsecured.
This is very interesting. But you are saying this is the law henceforth
Yes, this is the law henceforth.
for all other real estate companies and cases.
Yes. It is.
If this also involves land acquired from private parties by a builder and then which goes into insolvency, even then.
Even then, because the security is on the asset of the company,
Right.
it will all end up to going back to the language of the statute which governs that statutory authority.
Okay.
It will all go back to that in order to assess whether the security has been created for the purpose of that due or not.
Okay.
If it has been, then it is okay. But if
And
it is
JP is the first case where this has happened.
JP is the first case where a statutory authority has been declared to be a secured as well as an unsecured creditor.
Any implication of this decision?
The implication, one is that a resolution applicant who has given its plan prior to rainbow papers having coming in
Earlier. Which has been 2 years earlier.
2023,
23.
that they have a way out now. They do not have to go to court saying that my plan be rejected. Of course, with a little more money in their pocket, if they are able to show to the court that yes, we are ready to pay it, it will not result into the court saying that no, listen, I cannot modify this plan. I will reject this plan because that was the usual cause. Today we have a way out where the resolution applicant can go to court and say that this judgment I didn't know was there at that stage. And therefore, if you want to apply it to pending matters, I am giving you the money.
Okay.
So therefore, that kind of window that has been given, because Tarun, in this judgment of JP, Suraksha did not tinker with the treatment that were given to the financial creditors. It was not a case that we were decreasing the amount of the financial creditors and giving it to the Yamuna Expressway. We gave it irrespective of the plan. So if somebody is ready to do that, then there is a way out. And also at the same time, Yamuna Expressway is at a very, highly beneficial position. Basically, government becomes a beneficiary. So I think it's a welcome step, considering the fact that despite the judgment being applied retrospectively, if I may say so, there is a way out so that your plan remains.
But two interesting takeaways from today's discussion, which I would feel are good. First of all, the categorization of a secured and secured creditor. Second, you explained to us how a statutory authority can be a secured as well as unsecured creditor, how the claims goes up once he becomes a secured creditor. Yes. And we will like to discuss this some more with you in the next show, but it was an enlightening discussion. Thank you for answering all questions, and thank you for your time.
Thank you.
So that was Advocate Ishna Kumar. She answered on the issue of operational creditors, secured creditors, how a statutory authority becomes a secured creditor. Very interestingly, how it becomes both a secured and unsecured creditor. I enjoyed talking to Advocate Ishna Kumar and understanding this aspect. In the next show, we talk to her on IBC a little more on some different case, but that's it for now. Thank you, ladies and gentlemen, for joining in. Thank you so much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.